Hi folks, welcome back to the channel. Hope everybody is happy and healthy and doing well. So those of you who follow this channel will know that we've talked about cuffless blood pressure measurement before, and now we have an interesting opportunity to do it again because we have two companies that have launched just that, digital cuffless blood pressure monitoring in the US, and one is doing that with FDA approval, having followed the 510(k) process, and the other one is doing it without, and attracting, as you would imagine, some FDA attention. And so the first company is Actia. It's a French company. They received approval in July. And the second one is Whoop, and they received an FDA warning letter in July. And so we're going to take a look at both of these and talk about what it all means, both for us and for the medical device industry, and where this might go from here. Now, quick disclaimer, I'm not a lawyer, I'm not a regulatory professional, I'm not offering legal advice, I'm not offering regulatory advice. I'm just a guy on YouTube who thinks this is interesting and has opinions about it. So take it with a grain of salt. Now, what Whoop has done is that they've added blood pressure insights to the Whoop band, and it gives a systolic and a diastolic value, as any blood pressure measurement device would do. They claim to have validated it on some 32,000 sleep sessions with 11,000 plus members. However, they do not list any clinical trials that they've conducted, nor have I been able to find any clinical trials by Whoop testing blood pressure on clinicaltrials.gov, which is where you would normally register clinical trials, especially if they were conducted by any institution of any stature. Let's put it that way. Now, there is an interesting sentence at the bottom of this explanation of how they validated their algorithm. And it says that the FDA has not challenged the accuracy thereof. That's a little bit of a red herring, and we're going to get back to it in a little while. But to continue, as those of you who know something about this regulatory process for medical devices know, if a company wants to market a medical device in the US, they need to submit a pre-marketing application to the FDA, and there is obviously a format for that, and there is information that has to be provided as part of that, including information about clinical trials. And the FDA takes a look at it and either approves it or not, and based on that, you're either allowed to market your device in the US or not. Well, Whoop chose not to follow this process. And so they've now incurred the FDA displeasure, and they've received an FDA warning letter. It was sent to their CEO on July 14th, addressed to Dear William Ahmed at Whoop Inc., and it explains why the FDA is unhappy with Whoop. Starting with, and the FDA doesn't mince any words, in the first paragraph, under section such and such, this product is a device because it's intended for use in diagnosis of disease or other condition. And so, in other words, the FDA is letting them know right off the bat that they're violating the law. And it continues to do so further on when it cites the absence of a pre-marketing application from Whoop. Now, the crux of the FDA's argument is in effect that Whoop is driving without a license because they have not obtained an FDA license to market blood pressure measurement on their device. And the FDA is very clear about the fact that blood pressure is something that falls under its regulatory authority for the simple reason that it is inherently, and this is the crux of the matter, as far as the FDA is concerned, blood pressure is inherently associated with diagnosis of hypo or hypertension and is therefore intended for use in diagnosis of a disease or other condition, or in the cure, mitigation, treatment, or prevention of disease. That is the crux of the matter of what makes it a medical device which requires approval by the FDA. And the FDA continues to point out the simple fact that it is consistent with FDA's prior actions to have reviewed such devices. Now, if that wasn't enough, the FDA continues to disabuse WHOOP of the notion that blood pressure insights is somehow intended to maintain or encourage a healthy lifestyle. Because, as the FDA points out further on, blood pressure measurement is not considered some kind of low-risk wearable thing. It therefore doesn't fall under any exemptions. Providing blood pressure estimation is not a low-risk function. And thereafter, the FDA continues to explain why it's not. An inaccurate blood pressure measurement could have fairly significant medical implications, which indeed it could. And so FDA then finishes off by pointing out that FDA actively regulates devices intended to measure or estimate a user's blood pressure. There's nothing new here. Everybody who's been dealing with FDA, everybody who's done anything in medical devices with blood pressure knows very well that this is how the FDA views things. Now, WHOOP has responded publicly, and I'm sure they responded privately to the FDA as well, though we haven't seen that letter, and they maintain that they are exempt. In particular, they claim to be exempt under the 21st Centuries Act, which exempts low-risk wearables from cumbersome FDA regulations and approvals. And that is in fact true if you're dealing with low risk, which, as you've seen, the FDA does not believe that this is. And that is truly the crux of the matter here. Is blood pressure measurement low risk or not? And therefore, does it fall under FDA regs, or is it exempt by the 21st Centuries Act? Now, we mentioned Actia, which has introduced, or is actually introducing, but has received FDA approval for a similar device which uses PPG to measure blood pressure. And they've obviously taken a very different route. They followed the FDA process. They conducted clinical trials, in fact, 6 of them. They submitted a 510K and they received an approval. And they're not on the market in the US yet, but I think they will be probably end of this year or something like that. Now, there is one point that we skipped over that is worth mentioning here, and that is WHOOP has made the point that FDA has not pointed out or disagreed with the accuracy of the WHOOP device when it comes to blood pressure. And I said earlier on that that was a red herring. And it is, for the following reason. When you submit a PMA, you're obviously required to submit a certain amount of information to show that your device is safe and effective. I mean, that's the basic premise on which the FDA operates. The FDA does not conduct its own trials. It does not collect its own data with regards to safety, accuracy, or anything else. It relies on the data that is submitted by the company, which, however the company has collected it, there are obviously rules and regulations which surround clinical trials and all of that. And so for that reason, the FDA would at this point, since Whoop never submitted a PMA and never gave the FDA any data, FDA would not have a point of view on whether the Whoop device is accurate or not. And furthermore, going back to our car driving analogy, FDA doesn't really care at this point in time whether Whoop is sort of under the speed limit, over the speed limit. The only thing that the FDA really cares about is that Whoop has violated, as far as they are concerned, the basic rule of driving without a license, from bringing to a market a medical device capability without clearance by the FDA to do so. That is the hill that the FDA is going to fight, and that is the hill that they're going to die on if they need to. And they're actually right, if you believe that this is in fact a medical device functionality. And so where does this leave us? Well, FDA sent a letter on July 14th. It is now August 25th. I checked this morning and there is no enforcement action that I can find. So in other words, the FDA, or more actually the Department of Justice, don't seem to have filed a lawsuit against Whoop yet. And it would be the Department of Justice that would be filing the lawsuit on behalf of the FDA. Agencies like the FDA, EPA, etc. don't file their own lawsuits. The Department of Justice is the department that does that, obviously in collaboration in this case with FDA lawyers if they choose to do so. Now, let's think about what could happen going forward. There are obviously some discussions going on between Whoop and the FDA, and they each understand the other's point of view. They just happen to disagree as to which law actually applies to this. Is it sort of the laws under which FDA regulates medical devices, or is it the 21st Centuries Act, which provides an exemption? And it really comes down to sort of how important and vital and risky this feature is. So what's my opinion of this? What's my thinking? I think under normal circumstances, there is no doubt what the FDA staff wants to do and what the FDA and the DOJ would do. The FDA staff are obviously concerned about their authority and their ability to regulate things that they consider to be past a certain risk threshold. Does that mean that the administration is now going to file a lawsuit? Well, under normal circumstances, I would have been pretty sure that they would. With this administration, who knows? Ultimately, it's not only an FDA decision, it's a DOJ decision, and there are obviously political issues at work. And my sense is that Whoop did what they did, obviously knowing that they were skirting potentially certain regulations, knowing that they would incur the FDA's wrath. But they probably decided one of two things. One is that they might be able to get away with it in the political climate that we have right now with the administration that we have in place. Or two, that they had a fair shot in court even if the FDA, DOJ choose to bring a lawsuit. And it would be an injunction. The FDA, DOJ lawsuit would be seeking to enjoin Whoop from continuing to market this. And that is what would be litigated. Will be interesting to see. If we don't see some kind of legal action in the near future, that might mean that there's not going to be a legal action. And that would sort of send one message. And if there is a lawsuit filed, then we'll be able to follow that litigation, which is going to take some time, as litigation normally does. And it will be interesting to see what the courts decide. So that's as much as we know and as far as we can get on this one right now. Do I personally believe that blood pressure is important enough so it needs to be substantiated with clinical trials? Yeah, I mean, the fact of the matter right now is that none of us have any ability to know, before you subscribe to a Whoop device, how accurate their blood pressure measurement is. The whole crux of sort of having a regulatory agency, an FDA, review the data is so that we know that by the time something hits the market, it meets a certain safety efficacy threshold. With this Whoop blood pressure thing, we don't know how good or how bad it is. I mean, you can subscribe to it and then measure it yourself, but that sort of defeats the purpose. How many tests are you going to make before you decide that it's either good or bad? And how do you even know if your testing is good? Blood pressure measurement, unfortunately, is fraught with a lot of error in many instances. People simply mismeasure when they measure it, even with blood pressure cuffs. And so having some external validation as to how good the Whoop blood pressure measurement is, I think that is sort of a valid ask, quite frankly. And so I'm surprised that they haven't put out more data where they've sort of shown and documented how reliable it is, if nothing else. Just throwing it out there and saying, yeah, we've validated it with so many members, that doesn't tell me anything about how reliable it is, and that's, quite frankly, problematic. So, in any event, it'll be interesting to see where this saga goes. We'll keep you appraised as we learn more. In the meantime, thank you for watching. Be well. Take good care of yourselves. Bye-bye.